fine.
So,
Perfect.
okay.
Okay.
And sadly, I should have just rented a car in DC. The Uber was incredible. The hardest part is why is my chair
That's
so
crazy.
low?
Somebody took all those troughs.
I know. It kind of, we have looked and looked for them.
Talk to Sam. Yeah,
So
Sam
what I
went
need
through
to
all the
do-
buildings as well.
All we need to do is we need to label or mark those.
Yeah, that's what I was
property
gonna-
off. Do we have a sticker that says property off?
We'll spray paint them.
Something so that. Yeah, I mean, I shopped around, and that's about the cheapest. Cortez is about the cheapest. So
See, and they were aluminum.
oh, so these are poly cars. So they'll last
Yeah.
for a year good.
No, they'll be fine. But
So we
they're
shopped
aluminum,
and
but
shopped
they're
around.
expensive.
Aluminum were expensive. They were all very expensive, but
Yeah.
yeah. So we
Mitch.
anyhow, I sat right over on Friday. I'm like, okay, the house. I can't figure them out.
Okay.
But it bugs me because there's 7 of them.
Yeah.
Or no, 11.
Oh, really? Is that how
11
many
is
she
what I was
had?
told.
Hey.
Is there going to be a closed session here?
No, closed session is later today. That's
Okay.
after commissioning.
Okay, so what's going to be so with him?
Just all in work session. And so I didn't have
Is he
an
going to be
executive
with us
session
in
and
our
work
meeting?
session.
Or he's staying that long?
My room.
Yeah, I think it would be probably nice to clarify some of the things. Okay.
Do we?
Because this is a public meeting and work
I
session.
know. I just need 20 minutes if we end early. I've got a dentist appointment. If not, I'm gonna go to Bryce. Otherwise, I can run right there for 20.
What time's your dentist appointment?
9:30. But I says, can you just give me in if I get a break? And they're like, yes. So we'll see. We'll see. We'll see. I mean, I get it. I get it. It's commission day.
You're gonna come back, half your face is gonna be all.
Well, no, I get rid of these.
Oh,
They
okay.
just have to do my impression when I'm done.
Okay.
Just run in real fast and get it done. If not, I'm in them for like 4 more weeks.
Okay, I'm just totally picturing you
We
like
need to wait.
paralyzed on half of your face coming in here.
Oh.
Just
No, it's not a feeling. I think they just hurry and do my impression. I'm out of
Okay.
there.
We'll just
But I'll
wait.
see. I'll do whatever.
Oh, as long as we get Commissioner Harvey,
Yeah, and
and we'll
then
be
if
fine.
people take places, they need to
Either
sit
way.
where they need to sit.
They come down like they come down 1 day short, and then they come for 2 days, like in a month. Yeah, it is a small window.
Well, Jan's tries to keep taking my seat.
Overthrow the king, that's not what all good histories are about.
Yes.
Is this as good as it gets? Like this rough? It's tough.
All the tissues, yeah. Gotta have rough
Oh, the
bones
air.
around here.
I know. Doing the
You got a cold or is it hay fever?
I kind of had a cold junk, just throat junk. So I don't usually get allergies. Maybe I do have some. Did you drive down this morning, Johnny?
Yesterday. So you are down
Is I okay? I'm not.
Mm-hmm.
Okay.
Yeah, absolutely.
Okay.
Good morning.
Good
Yeah.
morning, Sylvia. How are you?
By the way, I have 2 baby kitties in the garage, so don't let Harley eat them.
Oh, you've got new ones?
Yes, I had to get 2 more.
How come?
Because I lost one of them, and I had to get some more.
What do you think happened to that cat?
I don't know.
I hope Harley didn't have anything to do
I don't
with
think so. I think it just ran off. It's okay.
it. I've
So
got the other one at my house right now. It is a
the other
character.
cat, I wondered
Your
where it was
cat,
because I was
yeah.
trying to get it to see the cats, but
Yeah, it's killed a couple of mice already.
Oh, yeah.
I walk in.
That's why I have 2 new cats, because he takes my cat. You wonder why.
His name was
Hmm.
Hoey White. He was the postman there in Spanish for the post office for years and
Get out my
years.
skin.
He was son that
Oh, there's a really rough one over there if you want it.
we're married.
What's that one?
There's a rough paper towel if you want to rub your nose dry.
I do have
I
I keep thinking, I have allergies so bad, I keep thinking, I hope I didn't take the wrong pill. The one is for to sleep. And
So
the other
you
one
fall
is to wake
asleep.
up. Well, I didn't sleep very much. We had lots of stuff in our agenda for us to digest. Oh my God. Anyway, so.
Are we waiting for
We'll just,
Commissioner Harvey? Or
Mac, should have
Oh.
Mac here.
Well, yeah, until I retire, I'm not gonna move it there now at this point. 2 years out.
Brian? Sneaking in quietly, huh?
Right. Mr. Harvey?
Do you wanna call and see how, in case he's nearby?
We're out in our,
Yeah, every county feels that way.
I sent you an email, I looked yesterday.
Oh, they're here, yes, okay.
good morning.
This is already in the packet, so I put mine over there because there's too much people. Wanna say yours?
Okay.
You're right back.
So you're ready.
It is a very heavy agenda today. Shall we get started?
It's all you.
Chance, are you sitting here or who's sitting here? Okay.
Mitch is coming.
Yeah, I think that's what
Okay.
Good morning. Good, how are you?
It's today, June 3rd, 2025, is 9:09, and we'll welcome you to the Board of Commissioners work session meeting. So we'll call to order and roll call.
Commissioner Mon here.
Commissioner Harvey, present.
Commissioner Stubbs here. And so we'll turn the time to
Okay.
Matt for
Yep.
agenda
This
items.
first agenda item is Commission Policy Rules and Order Training Discussion. Johnny, appreciate you coming down.
Thank you.
hear and see me better. So after several discussions, and actually even some concerns expressed by the public on the meetings, and sometimes there's questions on how the order of the meeting should be done. I sent you all a draft of rules of order and procedure that I put together several years ago for the counties. As I was out and doing open meetings training for counties over the last 10, 15 years, many didn't realize that there is a section of code 1753-206 that requires every governing body in the state of Utah to have separate rules of order and procedure for how they conduct their meeting. This is not the rules of how you govern yourselves, it's the rules of how you conduct a meeting. So parliamentary process. A lot of people, and the next thing I found was a lot of people would say, well, we just follow Robert's Rules of Order, which I've been doing this for over 30 years, and I have never sat at a commission meeting or a city council meeting or a special district meeting where they've used Robert's Rules of Order. And that makes sense because even in Robert's Rules of Order, it says that those rules are not for bodies fewer than 12. You shouldn't use them for a body fewer than 12. They're meant for very large associations and groups. And so in preparation, also Mac and Mitch helped me identify the San Juan policies and procedures of the San Juan County Commission, which I've reviewed, and I'll just read you the first sentence of this. These rules are made pursuant to section 1753-207 of the Utah Code. 207 is a separate code than the one that calls for rules of order and procedure. 207 says a county commission may adopt rules on how they govern themselves and how they conduct business. Not the meeting, how they conduct business. So how do you approve payments? How do you appoint an individual to a position? That's the types of rules that you can adopt under 207 if you wish. Now, reading through that, those policies and procedures, it's clear that when those were adopted, you sprinkled in a lot of the rules of order and procedure for the meetings that I think at the time the county had, because I had just adopted them for USIP, and Commissioner Adams brought a sample of those. So there are portions in that policy and procedures policy or ordinance that mimic the things that would be in rules of order and procedure. But I think one of the things to consider is whether or not, again, because it is two separate sections of the code, and because one is a may, you don't have to do it, you can if you wish, and the other is a shall, and there are some other prescriptions in there that I don't know that you're following now, that you do have two separate items so that you can keep track of them and keep them up to date. One of the things with the rules of order and procedure is that under the statute, those, once they're adopted, they need to be made available to the public at each one of your meetings. So you should have a copy of them here in the commission room for anyone that wants to look at those while the meeting's going on, to make sure that you're following the process that you've adopted for your meeting. And they must be on your website for the public as well, which your current policy of the commission is on the website. But again, I don't know that you have that.
So we're talking
here
about
at the
two
meeting.
different things.
Yes.
Okay.
Yeah. One is how you conduct business.
Mm-hmm.
The other is how you conduct a meeting.
Yeah. Okay.
And because the statute requires you to have those rules of order and procedure both at the meeting and on your website, you can't use the Robert's Rules of Order. They're trademark, copyrighted. You can't put them on your website. It's over 700 pages. You'd have to have the book here. And again, as I go through even some of the things that you have adopted as meeting rules under the policies and procedures, don't follow Robert's Rules of Order. So I thought I'd go through a little bit of this morning and just identify some of the issues so that we can move forward and work to develop a policy for how you conduct business if you want to continue to have one, because that you don't have to. It's a may. And then make sure that we get a rules of order and procedure put in place that, and again, this is policy based on the current commission. The policies, the pieces that are in the older policy were adopted by a prior commission. The current commission gets to run their meetings the way they want, as long as it's within the statute. So these should be reviewed on a regular basis. I don't believe that any of you were on the commission at the time that these were passed. Mm-hmm. So again, the questions of how do you do public comment? How do you do motions and things of that sort? You should review when there's change in the makeup of the commission, because they should have their own policy. Do it the way that they wish.
Well, and not only that, this is not dated, it's not signed. I can't find any resolution or anything of the commission actually adopting this.
The rule for the meeting, you mean?
Yeah, this thing here, so. So I guess the issue is, we don't know for sure that these have ever been formally adopted.
So are we talking about the rules or the policy?
Well,
It's like two different things.
yeah. And which would you like me to address first?
Well, I think let's start with the rules of the meeting first, so we can understand that, and then we can talk about the policy, because I think we're kind of
Okay.
so we can kind of clarify.
Is the 06 the shall and 07's the may?
Yes.
Okay, that's what I thought.
206 is the
Shall.
rules of order and procedure for meetings.
Yep.
That's
Yeah.
a shall.
Okay.
Yeah,
207 is
The may.
how you conduct business.
yeah.
That's a
And so
may.
let's talk about 206 then.
If you feel that it's for a commission that there's not enough clarity in the statute on how to conduct your business, that you want to have your own rules that further clarify how you do that. Like you have the rule here in San Juan that I don't know that I see in any other county, that everything needs to be done by resolution. That's a specific to San Juan, that other counties don't do that, use that method to take action. But again, that's your choice. That's what the statute is there for, that if you want to make those types of requirements on yourself, you may. Okay. So on the rules of order and procedure, again, I sent out the sample that I had sent out to county attorneys several years back. Might be two attorneys prior to Mitch and to Mac. And again, I based these off of kind of the way that Robert's Rules of Order are set up and the things that it addresses, but then I wrote them according to how I see commissions conduct their meetings. I've not yet seen a commission where the person who's talking has to stand in order to be recognized, and the entire time that they're talking, they need to under Robert's rules, you have to stand. You have to, no one can talk more than twice on any issue, including a body member. So once you've spoken twice on an issue, you're done for the day. That's Robert's rules. I've never seen a commission limit themselves in those ways. So under the rules of order, we have, first we address the chair, and the election of the chair. The language there, very similar to the language that you've got in your procedures now, as far as that you're electing the chair. The only odd thing is you identify that you elect or appoint the chair, and I'm not sure under what condition you'd appoint a chair. It generally is elected by the body who the chair is going to be. and I don't know that there's a need to appoint them afterwards, but just something that I'm not sure. I don't usually see that language of appoint, that's
Yeah,
an
we
option
make a-
to
they make
appoint
a
rather than
motion
elect.
And we pass a resolution of who the chair is for the year.
Yeah, it's probably because you do things by resolution
Yeah.
that you've got. So it's maybe more elect and appoint
Yeah.
rather than elect or appoint. So that people understand that that's not an option that you could just who would appoint them.
And we had situation where people volunteer. I mean, you know, I would
To be the chair, and then you make the
Yeah.
motion to
To
approve
serve,
them
you
as
know,
the chair.
so-
And,
Okay.
yeah.
Then the sample that I've sent out identifies the different duties of the chair, reviewing and approving the agenda that would be published for the public for each meeting, announce the item of business before the body in the order in which it is to be acted on. The agenda becomes a big issue in a lot of counties as to I get the call and it's who's in charge of the agenda. Sometimes the clerks feel that they're in charge of the agenda. They put it together. Sometimes it's the chair that feels that the chair is in charge of the agenda. And others feel like it's the entire commission. The commission that develops and identifies what's going to be on the agenda. The tricky part with the agenda is how do you do that? Because you can't take an action outside of an open public meeting. So if the three of you are going to all approve an agenda, you'd almost have to do it at the prior commission meeting for the next agenda, which is way too far out, right? Agendas sometimes aren't ready till that 24 hours.
And another thing, you know, we do things different from another counties because our distance.
Mm-hmm.
You know, it's not like Utah Valley, you know, 20 minutes you can meet somewhere and have a meeting, whatever. But with us, every time we do one thing, it's all day, you know. And so
Yeah.
lots of the things that are structured before, I think, is according to our circumstances, according to our, you know, our time.
Right. Because of course, what is and is not on the agenda can become a really important issue.
Yeah.
And so again, I think that's something that the commission should have discussion amongst themselves as far as how are we going to decide what's on the agenda and not. And in the rules, there's a section that talks about the procedure for someone to ask to have something on the agenda. I think the way I have it written is if a commission member wants something on the agenda, they just let the clerk know I want this on the agenda. If a member of the public or another elected official wants something on the agenda, then they fill out more or less an application with the clerk to, I'd like to have this on the agenda. That then the commission would review. If the commission wants to give those duties to the chair, and it's the chair that decides what's on the agenda and what's not, you can do it that way. If you all want to review it and each sign off that I'm okay with this agenda item or I'm not okay with this agenda item, then you can do it that way as well. But again, I think for people who show up to the meeting and not only do they want to comment, but they want you to take action on something that day, they have to understand you can't, by law, take action on something that's not on the agenda. So for them to know that there is a process, that they can contact the clerk's office, they can have that application for an agenda item completed, or talk directly to one of the commissioners, see if the commissioner wants to put the item on the agenda themselves, because it's important enough to the commissioner. But to go through that process to get their issue on the agenda if they expect that the commission's going to actually deliberate on it and or take an action on it. Because if it's not there, you can't.
It is like public notice and things like that, because we have a newspaper that comes once a week.
Mm-hmm.
We had to have 10 days, start prepare 10 days ahead to put something in public notice. And I think that everybody in this room has experience coming to meetings and sometimes not knowing, either not knowing the rules, whatever, but it have been very stressful when people show up the last minute with packets for us to read or trying to put something in the item, and it becomes from Friday on to me and
Yeah.
Mac talking about trying to figure out the dynamic and trying to reach out people if they don't answer emails and things like that. So it is, it's not as simple. The probably is for other counties. For us, it's more complicated and it's stressful because I think we all need this, all in this room need to know how to do it so we can have, the frustration of trying to figure out over and over. We're doing over and over the same thing. So,
Right.
thank you.
Yeah, because it's a learning process. Once the community gets to understand that oh, I can't just show up. I can't call the morning of the meeting and tell them I want you to talk about this. That there's a process. You should be asking about that a week or more ahead of time so that it has the time to go through the process and end up on the agenda. So the other big thing with the chair is that the chair generally, again, they conduct the meeting. So the chair also has the responsibility to decide whether or not different motions are in order or not. So if someone makes a motion on something that isn't on the agenda, well, that motion is not in order and it shouldn't move forward at that time. So again, the chair has a greater responsibility to make sure that they really understand each item that's coming along, what motions would be appropriate at the time or not. And that, of course, when you get to the portion on the motions that are available and what they're used for, it's important that the chair really understands those and is able to deal with those on how and the order that they're taken in and that sort of thing. So then we go into the section on the clerk or secretary. Again, there's now in your the policy that you've got now, approved or not, is there's a section on it. But again, I think it's good to move that from that policy to the rules of order and procedure, because that's where they're more attuned to, and spell out the duties of the clerk, what all they are doing in preparation for and during the meeting and after the meeting is important to have there. Again, for transparency's sake, because this is the policy that's going to be sitting here on the table for the public to look at and know, why is the clerk doing what he's doing? Oh, well, because it's here. That's his job. And it also talks about the quorum and how you identify a quorum, what you do. If you lose a quorum, you either recess the meeting until you get the quorum back, or you can discuss non-action items without the quorum. But that's something that I see sometimes commissions not following real closely, that when the commission gets up and walks out of the room and they continue to conduct business, and you really shouldn't be doing that. So that's addressed in these policies. Again, there's a section specifically on the agenda and how the agenda would be put together. I've given some different alternatives of how you're going to do that in italicized print so that you can see which way you want to do it. Because again, this is policy. You can do it the way you want to do it as long as the method you use follows the Open Meetings Act. And then we get to the actual parliamentary process. where the chair announces the item. You get a report on the agenda items. So staff or an individual from the public, somebody would come up and provide you information, give you a report, probably information in your packet as well. And then if you're going to have public comment on that item, that's where you would take public comment. Again, the statute is, and the court cases are clear. At a public hearing, you must allow everyone that wants to speak on a topic to speak to that topic. But in your business meeting, the public only has a right to observe you conduct business. They do not have a right to speak, to comment. If you want to allow them, that's up to you. You'd want to make that very clear in this policy as to when and how you're allowing the public to speak, and the rules that govern that. That you can limit the time, you can limit it to the item, but especially with some of the items, if it doesn't already call for a public hearing, many of the land use issues and stuff that come up on your agenda require a hearing as well. Mm-hmm. So you're going to open it up to public hearing, but when it's not, if it's an issue that the commission feels strongly about, we want public input, then you'd have that public comment after you've had the report from staff on it. And then you'd go to discussion and deliberation by the body. And wait for a motion to be made. So you've got your motion first. I put in here a motion second, but the Kane County Commissioner pointed out to me, in a commission of 3, you really don't need a second. At that point, his argument is that it's going to pass. So why have a second? Just go to the vote after a motion's been made. My feeling on it is, well, no, sometimes someone will make a second because that, again, calls for additional deliberation on the specific motion. So that body member wants to give the courtesy to the motion maker of, not that I'm going to vote for it, but I'm going to second it so that we can have additional discussion on your motion. So I still feel like you should have a second.
Oh, that's my question. Don't you have to second to have that discussion?
Well, not if your rules say that once a motion is made, then you deliberate the motion without a second. And some bodies, I don't know of any counties that do that. Maybe they started doing that in Kane County on the county attorney's recommendation. But I think most people see that and recognize that. But it's also important for each of the 3 of you to understand, just because you make a motion does not require you to vote in favor of the motion. All it's doing is opening it up for deliberation.
One of the things with Kane County, they do not have an administrator, so the 3 commissioners, they had to make the decisions. So pretty much they already know how they're going to vote because they had to talk about it because they're managing and being commissioners. So I think maybe there can be a difference in approach.
They have a lot more hands-on understanding of what's going on day to day
because
in
they
the
have
commission.
to manage the county,
right? Yeah, because
so,
they are supervisors
yeah.
of the different departments and committees and things that are out there. So that may be part of it.
So on the comment portion, just speaking of that, a couple of years ago, it was really a discussion amongst the commission of whether or not they even have public comments allowed. And so you're saying that now you can actually have public comments for each agenda item if you felt that it was a controversial item, you would, and that doesn't constitute a public hearing,
right?
For that,
yeah. If you could write your policy in a way that there is no general public comment on the agenda. We don't just do public comment because there's a lot of liability issues with that.
Yes.
People will bring up and discuss things or make comments that can create liability for the county. And again, that discussion's not really super helpful because you can't do anything about it that day.
Yeah.
So it's really just some information and on something that you don't see coming, don't know anything about. Again, going through the process. But if you say we don't have a general public comment session, but on certain items, at the commission's discretion, they can take public comment on an item.
Okay.
We kinda
So
like that.
Yeah.
that kind of presented a problem in the past where we would have one commissioner kind of open it up to not necessarily the entire public for comments. It was just this one area. It's like, okay, if you're, and he would call it the affected area. If you're the affected area, would like to hear what you have to say. But then you're isolating the rest of the county's citizens because they didn't belong to that affected area. And
Yeah.
so it got to where it was so controversial, we just left the public comments at the first and just acknowledged that, hey, this isn't a deliberation. Don't expect the commission to answer questions during this public comment period. But the items didn't have to pertain specifically to anything on the agenda. It could just be somebody coming in to raise a complaint. And so they kept those public comments a little bit separate from individual items.
Yeah.
So you're saying on these, so now the law allows you to have those public comments on individual
Well,
items
again,
on the agenda. Does a commissioner then take it back and like, well, I just really want to hear about those that are in the affected area?
the law has always, again, allowed comment, but not required it.
Yes.
The only bodies that are required now, and this speaks to the legitimacy of it. There was a bill 2 sessions ago that would have made public comment required, and in every county, city, school district, all public bodies would have to take public comment on items in their meetings. And at the end of the day, that got whittled down to only school districts, only school boards have to take public comment. All other public bodies are not required to take public comment at a meeting. Public hearing have to.
Yeah, those
Public
are dictated
meeting
by law.
Don't have to. So again, it's their discretion. If they
Okay.
want to take some comment, then they can. But they would, if they want to limit it in some way, I'd say you want to have that in your policy.
Okay.
So again, you in your public comment on an agenda item, if you're going to allow that, you feel that there's going to be times where you don't know enough about this, you want input from the community, then again, you'd spell out, is that all persons who want to speak get to comment? Is that only persons that are affected? Because I think that's a legitimate way to continue to keep the business of the commission moving forward effectively and efficiently, because that's your charge. Conduct your meetings efficiently and do your business. So by only restricting it to those that are actually impacted by that thing would be a reasonable restriction to put on the comment. But I'd say have that in your policy so it's clear to the community that's who gets to come and comment. Not someone from Colorado who has an opinion on it, because I've seen that here when I've attended. So,
I have a question.
Yep.
Because all of us are kind of basically kind of newer commissioners, and commissioners come and go, and these rules come and change. If it happened to be somebody in the audience, they may have an answer for some of the things we're dealing with. Is that appropriate to call the person? Did you recall when this was done or whatever?
Again, that you can do that in your rules. And typically I see that being allowed to the chair. That the chair has the authority to recognize an individual, because now they're not really the public, right? They're more an expert. Well, Jim, you were here 20 years ago when this came up.
Or even just a lead where to go look for information.
Right.
You know, I mean, for me, I just want to know by myself, you know, and so they don't have to give me their opinion. Go look over here, and I can go look for it.
Right.
It takes lots of hours for me to go looking, watching old YouTube videos and trying to find things when things happen,
Right.
and we, you know, we have max resource to a certain point, but before him, what was the things that happened? So anyway, I was
So I
just
think,
have a
Sylvia,
question.
you could handle that either in the reports on an agenda item
Mhm.
or the public comment. If you want to consider again that that person has certain information that the general public doesn't, that would help you, well, aren't you asking for that individual to give you a report? So you could consider that part of the reports on the agenda item, and you're going to call on that local area expert to provide you with that information so that maybe I'm here and you want to ask me
Yeah.
to pipe up in the middle
Yeah.
of the
Yeah.
commission meeting. Where in the statute does that say that? The chair could call on that person as part of the report, not comment,
Mhm.
but the report. You could do it either way, I think. So again, then ultimately, at some point, if you take comment or not, then you would have the discussion and deliberation by the commission members on the specific motion that's before them. Not general. You've already had your general discussion on the topic. Now you're back to discussing the current motion, and then you take your vote. I did note in your current policies, it is aged. There's a lot of references to statute that aren't accurate anymore. And one thing is you identify that you take a roll call vote in some sections. Now, elected officials, all their votes have to be by roll call. So every vote of the commission should be by roll call vote. Or that at least the clerk has to show it in the minutes. Did they vote yes? Did they vote no? Or were they absent? Those are the three things that the statute says the clerk can show in the minutes. So again, another day we can do the disclosure training, but if you have a conflict, you disclose it, but you still vote. The statute allows you to continue to vote even if you have a conflict. You just have to disclose it. And the statute really doesn't allow for the clerk to identify abstention from voting. I've never found anything in the statute that indicates that a member of a body would abstain from a vote.
Especially in our small counties, you have lots of conflict.
Yes.
You know,
You kind of need to do your, well, and it's a fiduciary responsibility too. That's again, so we'll do fiduciary training another day, but your fiduciary duty is to vote, to take action. So you want to do that. Then the chair ends the debate on the motion, and you take it to a vote. So again, you want to go through this session and make sure that you're all comfortable. I've limited that we don't have motion after motion after motion. There's the ability to have a substitute motion, and then you vote on the substitute first, and then you go back to the original. But tertiary motions and things of that sort, the sample I've cut out, but you certainly can do that if you want to get that complex. With only 3 commissioners, it's very unlikely that you'd have 3 or 4 different motions going at the same time. Who's making them?
Well, I saw a meeting on a San Juan County meeting when somebody made a motion, nobody voted, nobody seconded, and they just keep going over and over and over trying to they came up to what?
Yeah, right. Yeah, because that does happen. Motions made, seconds never made, so you don't deliberate that motion. Eventually, the chair moves on and asks for a new motion, and if you don't get a motion, eventually the chair would just move on to the next item. You're not taking action on that item today. Yeah. I did notice when it comes to making motions that in your current policy, you've got that the chair can make a motion, but only if they hand off the chair to another body member before they make their motion. And again, considering those policies also reference Robert's Rules of Order, when it comes to making motions, I hear over and over again from commissioners that the chair can't make a motion. Under Robert's Rules of Order, absolutely they can. The parliamentarian, the person running the meeting, if they are not a member of the body, they can't make a motion. So I think that's the confusion there, that many large associations, the person that is conducting the meeting is not a member of the body. They don't vote. They're a parliamentarian there with the expertise on how to run the meeting, but they don't vote, so they're not allowed to make a motion. But Robert's Rules is very clear that the chair, by being the chair, does not lose any of their authority that they have as a body member. So the chair can.
It's not necessary to pass that.
It wouldn't be necessary. It just seems kind of clunky to me.
Well, to me, it's not tricky. You know what I mean?
Now, if the body wants to restrict the chair that they can't make a motion, okay. But that's not Robert's Rules. And it may be that you want to limit it that the chair can, and rather than the chair has to hand off the chairmanship to somebody else first, maybe it'd be just that as a courtesy, the chair wouldn't make a motion unless there's no other motion forthcoming. So the chair asks for a motion, there's no more motion forthcoming, so then the chair would make the motion. What I think you'd want to avoid as a commission is having the chair have full authority to make a motion, and they're also the person who recognizes who gets to make the motion first.
Or calls for the motion.
Yes.
Like say, I call for the motion, and my motion is
Yes.
in the same breath.
And so, yeah, you wouldn't want to allow the chair to be able to take over by always making the motion first before others have a chance to. So that's something to consider. You could keep it the way it is. Nothing wrong with it. It just doesn't follow Robert's Rules. And I think, again, with a 3-person commission, I think it's important that person not lose their ability to have a good idea on how we resolve this and make a motion to do that. If there isn't another motion forthcoming from one of the other members. Something for you to consider. Okay.
I could see that happening in the past.
Right, yes. There's a section on public hearings, which again, very clearly regulated by the statute, so that's an easier one. Again, there's a section on public comment if you're going to have a public comment period at your meetings on the different options that you can use to conduct that, and again, keep the meetings efficient and moving forward, not dragging out till midnight, especially when you start at 10 a.m. And then, there's options here in the sample for having no public comment, what language would look like there, or if you're going to have limited public comment where you can comment, but there are only certain things that you can comment on. We're not going to allow comment after comment after comment that's the exact same comment, things of that sort. And again, the statute allows you to do that. So if you want to adopt any of those different options, again, it's your choice how you want to conduct your meeting. There's a section on closed session, again, more to assure that you conduct that closed session in accordance with the statute and the procedure that you use in the open meeting to close the session, what you do during the closed session, and then coming out of the closed session.
Now on that, just to make sure for just clarity's sake, now the law, so it used to be, and I've got to get with our agenda software makers to remove that, just kind of a blanket statement on our agenda that allows us to go into executive session anytime. Now, my understanding is the law requires that you actually have it as an agenda item that's publicly noticed, and the specific reason that you're entering into executive session.
It's not clear in the statute, Mac,
Okay.
that's how you do it.
So can we
That's
still have
been
a blanket
our
statement?
recommendation of how you do it. You could have
So we have a
request for
blanket-
executive session
Yeah.
so that the public's on notice that they might close the meeting. But when you actually close the meeting, you need to use the language of the specific reason that you are closing or having a closed session for.
So you can do that at any time, but your recommendation is to post it on the agenda prior so that that specific item is listed.
If you know that you're closing the agenda to discuss the professional competence, physical or mental health of an individual,
Yeah,
and you know you're going to do that,
yeah.
why not put it on the agenda so that the public knows? But if the public is used to that, you just have the item, potential executive session
Or is it
or
just
closed session.
Blanket statement that references the code. So each agenda, we just kind of have that the commission can call for a meeting at any time during the regular session if necessary for reasons permitted.
Right.
Under
Yeah.
that. Utah code.
I put them on my agenda, and here's the reason, is that after the closed session, generally I'll have an action item for the board to take action on the issue that they discussed in closed session. If you're going to do that, you have to have the action item on
You
the
do.
agenda, right?
Yeah.
So why not have the closed session on the agenda? Now, if you want to have on the agenda just a more general one, so that if a commission member wants to have a closed session to discuss an item with the understanding that action on it's not on the agenda, they can't take action when they come out of that closed session, that'd be fine. There's nothing in the statute that would restrict you from doing that.
Okay.
But again, I think the more transparent you are on the things you know you're going to do during the meeting, why not be more transparent?
So then in executive session, can you speak about two different items?
I don't believe you can, because again, when you go through the process of closing the meeting and
state why you're
conducting a
closing it.
closed session, you must the motion to close the meeting needs to identify the specific reason that you're closing the session for. So if you're going to do both, discuss the professional competence of an individual and
Do litigation.
litigation,
Yeah.
those are two different
Yeah.
reasons
Mhm.
that you need to specify. So my recommendation, just so that you don't get called out on it, would be close the session for the professional competence, come back into open meeting. If you're going to take action on that item and it's on the agenda, go ahead. Otherwise, the next item on the agenda is to a motion to close the meeting to discuss
Litigation. Yeah.
litigation, and you close the meeting to go into that, because also you need that on the record in the open public meeting minutes, and then in the closed recording, the closed session recording, you have to also in that closed session, you put on the recording what the meeting is, the date, time, place of the meeting, what it is for. So you'd announce again, this is to discuss the professional competence, physical, mental health of an individual. Announce the individuals that are there at the meeting on the record, unless disclosing that person's name is the reason that you didn't want their name to be known. So you wouldn't put their name on it if they're there. But because the statute requires you to do all of those things, Mac, that's why I think that the clear intent of the legislature is you hold separate closed sessions for each item that you're going to discuss. The other thing that I think I've seen it, and I know that the public doesn't like it, is when the commission says, well, now we're going into executive session. We've got several different items to discuss in closed meeting today. So we're going to close the meeting now, and we won't have any business after the closed session. So thanks for coming. See you next week. And it just doesn't look as good as the way that the statute's written, that no, you'd hold your closed session, and at the very least you come back to open public meeting and adjourn the open public
Correct.
meeting,
Yep.
and then you're done.
Yeah.
You don't send people home and then have a closed session.
Okay.
I can understand if you know that closed session, like a litigation matter, it could take an hour or more,
Yep.
and you've got people waiting out in the hallway
Yeah.
to come back to the meeting, but that's government. So just again, make sure that you walk through that, and a chair may even want to have a good script sitting ready for them each meeting of what they need to do when they close a session, what they read back onto the record when they close that meeting, and when you have to record and when you don't. There's a couple of items. The discussion of the professional competence, physical, mental health of an individual, and the item to discuss security devices and personnel.
Real estate
Those two items,
purchases.
you don't have to record the closed session, but the chair has to sign an affidavit saying that's the only thing we discussed in that session. Any other closed session, you must record. It's not a public recording, but a judge may want to listen to it if there's an allegation that you went beyond the scope of that item in closed session. The judge will listen to it to determine if you stayed within the confines or not. Then there's a section on if you're doing elections during a meeting, how you conduct the elections. In my sample policy, I've put electronic meetings right in that policy. The statute requires that if you're going to hold electronic meeting in any way, shape, or form, you have to have a policy on it. You can have a separate policy, but electronic meeting is part of the meeting. Why not have it right in your rules of order for meetings? So that's the way I recommend you do it. It's all in one place for the public to find. And then lastly, we get into the rules of conduct for a meeting, how people are to conduct themselves, to assure that there's proper decorum and professionalism at the meetings, both amongst the body, other elected officials, staff, and the public.
So you can prohibit BYU jokes.
And then,
Because Commissioner Adam is not here, so we're okay.
and then we'll have there's a section on suspending or amending the rules, which you can have rules to suspend the rules if you want for something that comes up that the rules don't work for very well, and so you have that ability to suspend the rules and move forward to do something that you wouldn't normally do. As long as, again, it's within the state code, that you can't suspend the rules to take action on an item that's not on the agenda. But
So I have a question on that regarding what is and what is not in the agenda. And I think lots of time that's what my frustration is, because you just don't know what is the proper way to say to somebody, you missed the deadline, or the work you bring is not to part. I don't know how to do that and be civil and not have this questioning. How come this make it look like people is not ready?
Right.
If it happens once in a while, it's okay, but when it's a constant, and then even people that should know the rules, and so it is kind of frustrating because I don't know. So I think that it would be appropriate just to say we need to reschedule this for next time because and.
Yeah, I think.
But I don't, you know what I mean? I don't know because.
Yeah, I mean, if it's happening regularly and it's just that people aren't going through the process to get something on the agenda, or they're not doing it on a timely basis, that's, again, I think you just educate them that this is our process. Because the state auditors made it a very important issue as he conducts audits, that he wants to see that agenda goes to at least the chair and is approved by the chair before it goes on the public meeting website. That his position has always been, and I think her position now, the lead auditor, is that staff is not in charge of the agenda.
Mm-hmm.
The body ultimately is in charge. Of course the staff puts it together, but what is on it and not on it at the end of the day is the body's decision. And so at least the chair should be sent to them, they approve it, or the whole body, one at a time, however you want to do that without conducting an illegal meeting. And then but have that process. And because you have to go through that process and still have the final agenda on the website 24 hours in advance of the meeting, they've got to get that information to you more closely.
Lots of time we get things Friday night or Saturday and even Sunday.
Mm-hmm.
And so it makes it hard. Like us commissioners are waiting for the packet to come on Friday. And it's okay for the public to have 24, but we have a size of this packet. We need more time. And so sometimes, and then trying to decide, okay, then we let them in or whatever. And so that is that. I just worry about my behaviors. How can I, how do we address that? We notice your packet, there's nothing in the packet, and the person said, here it is, and you just don't have to look at it. And so how graciously you can say, okay, we'll have to reschedule it, we have to do, I don't know.
Yeah, and again, that's why this policy is so important, because you can put that in the policy that in order to allow the commission to have the time to review the materials for the meeting, that a request for
a deadline,
an item on the agenda can't be provided less than 72 hours, whatever the number is. If it's Thursday at noon, you just count back the hours, and that's when it's closed. After that, there's no more requests for agenda items. Now, again, from time to time, you'll have something really important come up that you want to discuss.
They need to be put in,
and you couldn't have it on the agenda. There's no way with the Open Public Meetings Act to throw it on the agenda last minute. So your option is to, if it's really important, hold a special meeting, because you can always hold a special meeting. You just need to, again, do the notice on the public notice website, develop the agenda, and set up the meeting. But that's not a difficult thing to do. So you could have that meeting really probably not the next day, but the day after. So something comes up today that you really want to discuss, you want to take care of it. It's something that's going on the weekend, and you want to deal with it before it happens on the weekend. You could identify that we're going to put together a special meeting, and you could do it Thursday. Easily enough.
Thank you.
And then lastly, here's the section on the enforcement of the rules, removing people that are disrupting the meeting. The language in your policy currently is a little softer than the code is right now. The code is you can only, it says that there's nothing in the code that prohibits you from removing a person who is disrupting the meeting to the point where it's not efficient and effective anymore. You can't conduct business. But the language they used, and I reviewed it again this morning, really again is nothing here prohibits you from doing that. It also doesn't prohibit you from removing someone for less. I think that's the idea and the intent, that it's got to be to that level before you remove someone from a member of the public from the meeting. But technically, that's not what it says. It says you can do it when they are disrupting the meeting to that level. No question about it. Can you, for a lesser reason? There's nothing that says you can't. You'll notice in the sample that I've done, I also put in some notes for the chair and kind of some scripts and things like that at the end, just for the chair to have available to remind themselves, especially as you first take over the duties of chair, how to walk through a meeting. But I don't refer to sections of the code in the policy, and here's why. They get dated really, really fast. So, again, just going through the policy that you have now.
6 years old and already
yeah,
references or
yeah, there's reference to the quorum can't convene in violation. That's still there, but it's now under a different number. There's some references to definitions in the Open Meetings Act that those definitions don't appear in the Open Meetings Act anymore. So as you look at the rules of order and procedure, and as you look at the rules of how you govern yourselves, I'd go back through that rules of how you govern yourselves and at least update the citations, if not do away with them, and just use the general language of the statute, or just rather than have language and then cite the statute, just say you're going to do it in accordance with the broader section of the statute. And then as the language changes, your policy's automatically updated rather than the county attorney having to go through after each legislative session. Because the Open Public Meetings Act especially changes almost every single session. So you'd have to keep up with it every year. The Attorney General's supposed to, by statute, notify you of all changes to it, but in the 17 years I've been doing this, he's never sent me that notice. So unfortunately, we're not getting that, but it's just easier to keep your policies up to date if you don't use those very, very specific citations. I would, again, if you're keeping the rules on how you conduct business, you've got a section on the county attorney and getting legal counsel, and it gives the commission the ability to ask the legal counsel, the county attorney, for information. I'd suggest that you put some language in there of why that's important, because again, under the statute, if you ask the county attorney for his opinion on an issue and he gives it, and you follow it for the most part in the decision you make, now you have legislative immunity. You cannot be questioned on that decision because you went according to the county attorney's recommendation. And that's really great for me because it saves you from lawsuits. And so that may be something to put in there so that you're reminded and future commissions understand that that's why we ask for the county attorney's opinion on things, is that it provides us that extra layer of protection, the county, that extra layer of protection for the decisions that we make. And again, as you go through that, and if you want, I'm more than happy to review it. I made notes of several things that the language is old again. The statute's changed a little bit. So if you're going to keep some of these things, there may be updates to the language that I'm more than happy to work with you on if you're going to follow through with that.
Maybe after we all review it, we can send it to you. You can take a look and
Happy
make
to
more
do that.
recommendation for us.
Yep.
So the resolution that you have today on the agenda, is that to adopt those?
Yeah,
Policies.
I did go through and make some changes. I think when I downloaded it, there were we changed the format of it a little bit. But
we will.
given today's conversation, I think maybe Johnny and I could get together and.
Can we participate on that?
Well, I was
Put it
gonna
in a
say,
work
me and
session.
Johnny can, get together and submit a draft with the updated provisions
Yeah,
and
'cause I
after
think,
the
yeah,
suggestions that have been made here today, present it to the commissioners.
Well, I think it'd be nice in our secret meetings to just talk about some of the issues and see why we do things and be part of the decision, because when I was reading in the agenda, I was wondering who was part of the decision making. And, I feel like with an attorney, if they can educate us as we go. And that's the reason to me it's important they are here, because we don't know, all the rules.
right.
And so I know when I was in a meeting with her, a close meeting, I tried to make her comment on something else, and she went, shh. And I could tell why she was trying to be quiet. But you see, I mean, we don't know all the rules, and that's why it's important to have them here so they can notice those things and be counsel to us.
Right.
And so, but I think I would really like to be part of
Yeah, because
the
I think,
decision why this work and why it's good to have it this way, and
Right.
obeying the laws, and then making, and with the lawyers there, I think we should have both attorneys there when we are working with that. So
Just to clarify and see which works better, I don't care either way. But either the suggestions come in, like said, in a draft, and then we get together and discuss those, because I certainly cannot remember all the changes. Or do we discuss the changes prior and then the draft?
I think it'd be good for us to be part of the decision, because we
Well-
have the final say on things, and so it'd be nice to know why we do. And this being helpful for us, and I think it's nice for us to know the process of how we came to this decision, and
if I could
and
suggest,
then we can, and
maybe
with
what we
the
do
attorneys
is-
being there.
Mitch and I can work on separating out
That would be
the
helpful.
207 from the 206.
Yeah, yeah.
Make sure that we've got those two separate items, and then we can have the draft again with indications of this is statute. So this is going to stay the way it is because you don't have a choice. This is the way you have to do it. And then the sections where this is policy of the commission that we want, this is the part that we want to go into a work session and talk about.
Yes.
How do you want to do this? And have the meeting there. But we've already got the basic format of both
legal.
policies set and what issues that we're going to identify or deal with in each one of them, so that we can move through that
That would be
without
Great.
taking a whole day to
At
do it.
least it gives us something to work, a starting place to work with, especially that separation.
Yeah, I like to be able to understand both, because I
of them
didn't
need to
sleep
be
good
updated.
last night worry about that one. How do we decide this? We don't have a chance to look at it. We don't know how it got started. And so I feel better this way. But and I think being part of the process, we can answer question why we did it this way,
Yes.
and why
Absolutely.
we changed it and we were changing. And it's important that we understand that, so that when the public is asking questions, then we know, well, this is why we're doing this or that, whatever.
Right.
But-
Yeah. And especially with the rules on how you conduct business. Again, it was done several years ago, a whole different commission. There may be issues that you guys have found, this current commission has found, that you're not sure how you should do this.
Yeah.
That now we can create a rule for you, so that when this type of an issue comes up, here is how we're going to. We've decided this is how we're going to deal with that type of an issue,
And that
because
was kind
that's
of the
what that's
difficulty
for.
with the commission policy is when I first got here, we had a work session that was all the agenda items that were going to be in commission meetings. So we would present in work session the whole entire agenda, have the discussions, and then we'd go into commission meeting with the exact same agenda, have the same discussions again, because that was the public meeting. And so when you look and you read through this, the work sessions are intended to be identical. But after
Yeah.
a couple months, I'm like, why are we duplicating our process, duplicating staff time? Let's just push all of the business to commission and have work sessions where we can discuss items like this that
Administrative items.
yeah.
Yeah, and really, again, HB 36 that overhauled the Open Meetings Act in the 2024 session. I worked very closely on that one with the representative because he had been to a couple of my trainings as a city council member years ago. And that whole statute, unfortunately, arose out of San Juan County and how meetings were being conducted in San Juan County. So and clearly, again, now the new restriction of what you absolutely cannot do under the Open Meetings Act is predetermine a decision on a relevant matter. Something that's going to be on the agenda that you're going to vote on is a relevant matter. You can't predetermine. So even with this policy, well, we can have a work session. We can have discussion. Mitch and I can do the final draft based on what we're hearing in the discussion. But what we don't want to do in that meeting is the three commissioners say, so we're all good with this and we're going to vote yay, right? That's what you can't do outside of an open meeting.
Before us ready to make a motion and we don't know what to say.
Right. But even when we bring the final draft, we maybe didn't hear you correctly and you'd want to make last minute changes to it at the commission meeting before you adopt it. Yeah. And that's why commissions need to be careful, I think, with the work session prior to the commission meeting, because when they come in and now they've had all the discussion and they go through the meeting, they go agenda item, and there's no debate, there's no deliberation. It just doesn't look right to the community. And that's the purpose, is they want to see you take your actions, but they also want to hear your deliberations. What small issue is it that two commissioners don't quite agree on, and how did they arrive at a compromise that then is in the motion? That's the piece that the legislature wants to make sure the public gets to see you doing.
Thank you.
You bet.
Thanks.
All right.
It's been great.
Every time I see you, I remember when I first met you, and you were doing presentation and those meeting about the new rules for the three commissioners. I always felt like I was being bad because I was kind of fighting that, but I appreciate that. I have one question, and as commissioners, I know I had one visit with you, and you seem to know lots of things that are going on in the county that's coming through from different sources. What is appropriate when people have concern? Can everybody be calling you, or is there a procedure how we go in order for whatever people have concerns, so you don't have to be knowing?
Yeah, my board wants to make sure that I'm making myself available to the counties to ask questions, be directed to appropriate statute and other counties that have policies that maybe would be helpful for you to know about, things of that sort. But I don't mind different people contacting me, but with the understanding that I work for San Juan County. I don't work for Commissioner Mon. I don't work for Mac. I don't work for Mitch. I don't work for Stilvey. My obligation is to the county. So when individuals call me, they have to understand I'm going to give you the answer based on what the statute says. And if I'm not picking sides, the only side I pick is what is best for San Juan County to be compliant and efficient and effective, and most of all, not creating liability for themselves. Because again, that's why the board wants me doing this, is so that you're not ending up with lawsuits filed against the county because whether it's non-compliance or that your indecision, poor decision, that you didn't communicate your decision as well as you could have, ends up with somebody bringing a lawsuit against the county. And most of the time those lawsuits are gone with a dismissal because it was just a misunderstanding and you did do things the correct way. But if we can avoid them, that's much better. So as long as everybody has that understanding that when you ask me a question, I'm giving you the answer based on this is the answer that the county needs to hear. Not I'm not picking sides. That I'm not. That doesn't help anyone, because quite frankly, you've all called me individually. You all have very good points, and there's issues that that should probably change. But then again, all of you have also brought up issues that no, not really. That's not right. You have to understand that it's different, and that's what you're going to get from me. And so as long as people aren't calling me to win me over onto their side, because I can't and won't do that.
Thank you.
Mm-hmm.
Thank you.
Thanks, Johnny.
Do you want a motion?
I guess we'll make a motion to adjourn.
So I'll make a motion to adjourn.
I'll second it. Commissioner Harvey had to step up for another meeting, so time to adjourn.
Thank you.
Thanks,
Thank you.
guys. All right. Don't come back numb.
I won't.
So, did you want to just